Most of us are aware of double jeopardy, the right not to be tried twice for the same crime. But the courts have adopted a dual sovereign doctrine to get around this pesky little problem. Two Supreme Court cases out of Oklahoma show how good intentions often lead to bad problems and how the court makes up the rules as they go along. We'll look at how this concept of dual sovereignty can be used to violate both your rights and the Constitution of the United States. Next on the Constitution Study. Hello there, everyday Americans, and welcome to the Constitution Study. This is where we read and study the Constitution. We teach a rising generation to be free. We teach you to be free. I'm glad you could join me today. I hope you'll head to the website, constitutionstudy.com. You can find more of these articles, videos, audio. You can ask questions. You can get engaged. The Constitution Study is here to help you better understand the Constitution and your rights, but it only works if you participate. So join me there, and I'll talk a little bit more about that at the end of the program, but for now, let's talk about this dual sovereignty. To understand the dual sovereignty doctrine, we need to understand the Double Jeopardy clause of the Fifth Amendment, which reads, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." The idea of the Double Jeopardy clause is simple. Government only gets one chance to convict you of a crime. In the United States, we have multiple governments. We have the federal government, and one for each of the 50 states, and I don't know how many county and city governments. Now, does the Fifth Amendment apply to all of these governments? Yes. There's no language in the Fifth Amendment to limit it to just one government. So what happens when a state tries someone, yet doesn't get a conviction? Is it possible to get another chance once jeopardy has attached, as the legal eagles would say? Enter the case of the United States v. Lanza and the dual sovereignty doctrine. It follows that an act denounced as a crime by both national and state sovereignties is an offense against the peace and dignity of both and may be punished by each. Here, the same act was an offense against the state of Washington because of violation of its law and also an offense against the United States under the National Prohibition Act. The defendants thus committed two different offenses by the same act, and a conviction by a court of Washington of the offense against the state is not a conviction of the different offense against the United States, and so is not double jeopardy. This case was somewhat unique. Lanza was charged in 1920 with manufacturing intoxicating liquor, which had been made illegal in 1919 with the ratification of the 18th Amendment. Quote, "After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the transportation thereof into, or the exportation therefrom the United States, and all territories subject to the jurisdiction thereof for beverage purposes, is hereby prohibited." Now, what makes this unique comes from Section 2. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. The language of the 18th Amendment specifically provides for concurrent power held by both the United States and the several states. It was the only instance where power was shared between two governments. In no other place under the Constitution of the United States is power shared, as we read in the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by to the states, are reserved to the states respectively or to the people. So when the Supreme Court found that Lanza had committed offenses against both the state of Washington and the United States, it would seem valid because under the 18th Amendment, both governments had concurrent jurisdiction. However, as courts often do, they have taken one phrase from this opinion and used it to come to decisions completely divorced from the original opinion. In the Lanza case opinion, we find we have here two sovereignties deriving power from different sources, capable of dealing with the same subject matter within the same territory. The Lanza court made one mistake in this language. While they were dealing with two sovereignties, they both derived their power, in this case, from the same source, the 18th Amendment. Since this is the only place in the Constitution that gives concurrent jurisdiction to both the states and the United States, and since the 18th Amendment was repealed in 1933 by the 21st Amendment, this unique situation no longer exists. Which brings us to the case of Oklahoma versus Castro Huerta, which held the federal government and the states have concurrent jurisdiction to prosecute crimes committed by non-Indians against Indians in Indian country. Now, Victor Manuel Castro Huerta was charged and convicted by the state of Oklahoma for child neglect. Now, what brought this case to the Supreme Court was the question of jurisdiction. See, while Mr. Castro Huerta is not an Indian, his daughter is. Also, the crime took place in the city of Tulsa, which, according to the Supreme Court in the case McGirt versus Oklahoma, is mostly part of the Creek Reservation, making it Indian country and therefore under the jurisdiction of the United States. This is where the problems with this dual sovereignty show up. Was Mr. Castro Huerta in Indian country and subject to federal jurisdiction, or was he in the state of Oklahoma and subject to their jurisdiction? See, according to the Supreme Court, both the state and federal government have concurrent jurisdiction. How can that be? Does it matter that the defendant is not an Indian while the victim is? No. If you, as an American citizen, commit a crime in Canada or Mexico, the United States does not have jurisdiction. If the crime occurred in both Indian and non-Indian jurisdictions, well, then maybe both governments would have a case, but that is not concurrent jurisdiction. It is a crime committed in multiple jurisdictions. For example, if someone performs a mass shooting crossing state lines, the states can charge the accused with the shootings within their states. However, because the crime crossed state lines, does that make it a federal crime? The federal courts say yes, but the Constitution does not. This case is a little different. See, crimes like kidnapping and murder are not inherently federal crimes. Congress only has the power to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may by secession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or any department or officer thereof. See, this means that Congress can make laws for Indian country, but not for the rest of the city of Tulsa. Remember, under the Sixth Amendment we find, in all criminal prosecutions, the accused shall enjoy the right to speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have previously been ascertained by law. That means that Mr. Castro Huerta has the right to be tried in both the state and the district where the crime was committed. Now, this should determine which government has jurisdiction, but the court had other ideas. I have not taken the time to discuss the question of whether or not the United States has the legal authority to own Indian country. That will have to be a discussion for another day. But by holding that the state of Oklahoma and the United States have concurrent jurisdiction, the court has violated both the Constitution of the United States and the rights of Mr. Castro Huerta. Now, since child neglect is not a power delegated to the United States, the only place they have jurisdiction is in Indian country. Now, since, as far as I can tell from the court's opinion, the crime occurred in Indian country, then Mr. Castro Huerta's appeal should have been upheld, since the crime took place on federal land. By allowing the state of Oklahoma to try him for a crime that took place on federal land, the court has exposed Mr. Castro Huerta to double jeopardy. If the court is allowed to make up the rules to satisfy the justice's own sense of what is right, then the rule of law has failed. Of course, this would not be such an issue if Congress had not taken over vast tracts of public land as the price of a state's admission into the Union. The protection against double jeopardy is very important to due process. While so far the federal government hasn't attempted to prosecute Mr. Castro Huerta, think of how many cases where the defendant was found not guilty in state court only to be charged with the same crime in federal court. This is a violation of double jeopardy, but the Supreme Court has given its stamp of approval under the dual sovereignty doctrine. While the Constitution does recognize multiple sovereigns, it does not give them concurrent jurisdiction except dealing with intoxicating liquors. So when Congress empowers federal law enforcement to enforce laws outside of federal land, it's just one more example of the laws of the United States that are not made pursuant to the Constitution and are therefore void. See Marbury versus Madison. Now keep that in mind the next time you hear someone being charged in both state and federal courts. This whole dual sovereignty, it's a tricky little thing. Yes, the 18th Amendment created it, and when it was repealed, it kind of left it in place, but only dealing with intoxicating liquors. But it has been expanded by the courts to include, well, just about everything. We have the claim by the court that child neglect, a power not delegated to the United States can prosecute that in another jurisdiction, in another territory, on land that the federal government doesn't own. This is dangerous because this means your double jeopardy rights are pretty much shot unless you commit a crime solely on federal territory because Congress hasn't dealt with it or hasn't dealt with it well. My personal opinion is Congress should deal with the question of Indian territory. Is most of Oklahoma Indian territory, or is it the state of Oklahoma? Once you deal with that, the problem goes away. But since Congress refuses to deal with that and the court decided to step in and make its mess there, Mr. Castro Huerta is exposed to double jeopardy. And so may you be. There's a podcaster I listen to who often talks about if people who use firearms during the commission of crime are not punished properly under state law, they should be charged under federal law. That is double jeopardy. Because the federal government has no authority to enforce any gun control law outside of federal land. And again, the whole discussion of federal land is a discussion for another day. I hope you learned something. I hope maybe this got you to think about this maybe a slightly different way. Maybe you'll see examples of double jeopardy or this dual sovereignty doctrine and its abuse. Bring it to our attention. Go to the website, constitutionstudy.com. Ask a question. Get engaged. Get involved. The government gets away with this because the vast majority of the American people do nothing when they see these crimes take place. Now, you can join me there. You can support the work that I'm doing. I'm working hard. I'm going to North Dakota, Idaho, and Wyoming shortly, and you can help support the work that we're doing here. Now, you can join the Blessings of Liberty tour. Just go to constitutionstudy.com/tour, and you can support the tour. You can find out where I'm speaking. You can even ask me to come speak to your event. But if you support the Constitution Study, help pay the bills so I can bring this information, I can bring this message to more and more people without having them make them pay for it, I would appreciate it greatly. Right now, the Constitution Study runs on whatever money I can donate to it. If you can help, that would be tremendous, and it would be tremendously appreciated. Also, if you'd like to find a group of scholars that are also interested in studying the Constitution, we'll go to constitutionscholars.com. You can sign up for free. You can get access to a bunch of resources, including groups for your individual states. Maybe you'll decide to buy some material there or join one of our mentoring groups. It's all there. Again, constitutionscholars.com. The important thing is, John Jay said that we need to read and study the Constitution so that we will know when our rights are being violated and be better prepared to defend and assert them. That's what we're trying to do here. So I hope you will join me and the rest of us here next time at the Constitution Study.